Good evening, students. Today, let us see certain aspects from the examination point of view. That means, now already the final timetable of examination timetable of KSLU has come. Next month, you are having the jurisprudence paper, and most of the students, they have requested me to do the audio on jurisprudence. That means they feel that this subject is very much difficult, especially our law college students, Likita Manjunath and Kavita Rani. They have requested me to do this video in the interest of the examination. So here the students, they feel difficulty with regard to this jurisprudence, and it is the common notion among the students that jurisprudence is difficult. Here there is some reason is also there for the students why the subject jurisprudence seems to be difficult, because here we cannot expect the same questions, we cannot presume, we cannot expect the same questions each year, and the answers in jurisprudence requires utmost clarity, and this subject seems to be a little bit difficult to get to understand. So these are all the reasons projected by the students. Here what I want to say to you, jurisprudence is not a difficult subject, it is a simple subject. Here it is also has been done under 5 units. Probably you may see here, that is unit number 1, 2, 3, 4 and 5. And here with regard to the jurisprudence, we have to make the mind mapping. So either we can study jurisprudence under the unit 1 and 2, 3 and 4 and 5, or we can study the subject like mind mapping. So which are all the aspects we have to cover under the mind map 1 and 2 and mind map 3 and 4, and likewise it will continue up to 21, it will continue. That means here what is mind map means, what are all the important things which can be covered, what are all the things which can be covered. Here most of the students, they feel difficulty in remembering the points. Most of the students, they feel difficulty in remembering the points. Once the word jurisprudence has been said, they felt a difficulty. Here the jurisprudence has been graded under the most difficult subject. Here why? Because the method of study our student don't know. Here we have to study the jurisprudence as like a story. That means here, as you know, your lecturers might have explained to you what is the importance of the jurisprudence, what is the prominence of the law, and what is meant by jurisprudence. All those things they have explained to you. That means without law there will be no jurisprudence, isn't it? So here we don't have the jurisprudence without the law. So those things probably your lecturer has told you, your professors might have told you. Here in society, everything will run under the control of the law, isn't it? If there is no rule is there, if there is no law is there, if there is no social control is there, then we will find very much difficulty. For example, presume one day there will not be any police to control the traffic. What will happen? Presume that if there are no police for entire day in any city or town, what will happen to the fate of the people? The other side of the things we should not have to discuss. So here, what I want to put you that here we have to study the law under the jurisprudence. Here, what is meant by jurisprudence? You know, jurisprudence is nothing but the science of law. Jurisprudence is nothing but the science of law. Here, what is meant by law? Here, with regard to the law, there are so many definitions are there. There is no clarity with regard to the law. So, there is no clarity with regard to the law. So, with regard like this, we have to discuss certain things. Now, there is a very shortage of time is there. From the interest of the examination, most of you are expecting only the most likely questions, most important questions from the examination point of view. Which are all the most important questions will be given in the examination. Here, with regard to the most likely questions, I will give the most likely questions in this video only. And in the examination, with regard to the mind map, for example, 5 and 6, 1 and 2, and with regard to the 15 and 16, likewise the 3 and 4, likewise the certain, with regard to the certain mind maps, there will be questions as come up in the examination. Here I was telling you with regard to the meaning, nature and values of jurisprudence and its definition. Here there will be question with regard to this chapter also. Here we can find the questions with regard to the chapter number 1 and 2 in various examination. Here the question may come in this way. Discuss the nature and value of jurisprudence. In this way, the question may come up in the examination. Certain times they may give the individual questions may be given. Discuss the value of jurisprudence or discuss the meaning and nature of the jurisprudence. So certain times they may ask you, what are the definitions concerning to the jurisprudence? What are all the definition concerning to the jurisprudence? Here in this first chapter, we have to see the meaning, nature, values of jurisprudence and its definitions. Here, why I am saying this thing, here if you get ready for values of jurisprudence, if the question comes for meaning and nature, then there are chances that you could not able to write the answer properly. That's why not only this examination, for any examination, for any competitive examination, you have to get prepared in all the respects so that you can able to answer the questions very effectively. Likewise, with regard to this chapter, there are also the relations will also attain importance. For example, sociology, psychology, political science and legislation, ethics and theology. Here, certain times the question might be coming with regard to what is the relationship of jurisprudence with regard to sociology. As I was telling you, in sociology, it is what is meant by sociology, it is the study of society. Here, the human relations we are going to study. Here, we are going to study with regard to the societal control over the individual we will study. So, these sort of things are very much related to our subject. So, in examination, these questions may come up with regard to the relationship of jurisprudence with the other the sciences, that is sociology, political science, and ethics and theology. Likewise, the questions may come up in the examination. Here, the questions are explain the nature and scope of jurisprudence. In this way also, the question may come up in the examination. So this is with regard to the first chapter. And with regard to the second chapter, here they can ask you with regard to the meaning, definition, purpose of law. They may ask you with regard to the scope of jurisprudence also. They may ask you in the examination with regard to the mind map 3 and 4. Here probably you can see here you can know we have to cover the definition of various the juris, and you have to cover the definition of Solomon. Here Solomon has given the definition with regard to law in a specific sense as well as in the broader sense. Here there is no what you call complete definition with regard to the law. ಅಂದ್ರೆ ಈ ಕಾನೂನಿನ ಬಗ್ಗೆ ಒಂದು ಸಂಪೂರ್ಣವಾದ ವ್ಯಾಖ್ಯೆಯನ್ನು ನಾವು ನೋಡಲಾಗುವುದಿಲ್ಲ. ಪರೀಕ್ಷೆಯಲ್ಲಿ ಅದರ ಕಾನೂನಿನ ಅರ್ಥ, ಅದರ ವ್ಯಾಖ್ಯೆಗಳು ಮತ್ತೆ ಅದರ ಉದ್ದೇಶದ ಬಗ್ಗೆ ತಮಗೆ ಪ್ರಶ್ನೆಗಳನ್ನ ಕೊಡಲಾಗುತ್ತದೆ. Here you have to make the preparation with regard to this chapter. Certain times they may give the questions with regard to explain the function and purpose of law. In this way also the question may come up in the examination. Here I don't find the time to explain all those things. That's why today I will just give you the mind mapping. That means what are all the things you have to cover under these mind map things, so that it will be very much easier for you to what you call follow. Otherwise, if you certain words has come, Grannaram, Kelson's theory of law, then you will get frightened. So there is no need of getting what you call frightened or with regard to any sort of things. Here in entire jurisprudence, what you have to see here, we have to see the certain schools and certain things which you already studied in the first year. In first year you have studied the law of torts, contract, and the IPC. Here with regard to those things only the questions will be asked. But only thing is you have to discuss those things. For example, in law of torts, you have studied the vicarious liability, absolute liability, strict liability. So here you have to discuss those things in a critical way. So you have to discuss those things in the what you call, you have to give your critical analysis with regard to the subjects you have studied in the first semester and the second semester. So that you have to, it is very much easier. ಅಂದ್ರೆ ವಿದ್ಯಾರ್ಥಿಗಳೇ, ಈ ನ್ಯಾಯದರ್ಪಣ ಶಾಸ್ತ್ರ ಇದಕ್ಕೆ ಉತ್ತರಗಳನ್ನ ಬರೆಯೋದು ತುಂಬಾ ಲೆಂತಿ, ತುಂಬಾ ಹೆಚ್ಚಾಗಿ ನೀವು ಉತ್ತರಗಳನ್ನ ಬರೆಯೋದಕ್ಕೆ ಏನು ತಮಗೆ ಒಂದು ಏನು ಯೂನಿವರ್ಸಿಟಿ ವಿಶ್ವವಿದ್ಯಾಲಯ ಆಗಲಿ ಅಥವಾ ವ್ಯಾಲ್ಯೂಟರ್ಸ್ ಆಗಲಿ ನಿರೀಕ್ಷೆ ಮಾಡೋದಿಲ್ಲ. ಅದರ ಬಗ್ಗೆ ಒಂದು ತುಲನಾತ್ಮಕ ಒಂದು ಅಧ್ಯಯನ ಅಂದ್ರೆ ನೀವು ಅಪಕೃತ್ಯ ಕಾನೂನಲ್ಲಿ ಈಗಾಗಲೇ ಕೆಲವೊಂದು ವಿಷಯಗಳನ್ನ ನೋಡಿರ್ತೀರಾ. ಅದು ಸ್ಟ್ರಿಕ್ಟ್ ಲೈಬಿಲಿಟಿ ಆಗಿರ್ಬೋದು, ವೈಕರಿಯಸ್ ಲೈಬಿಲಿಟಿ ಆಗಿರ್ಬೋದು ಅಂತ ವಿಷಯಗಳು. ಮತ್ತೆ ಇದರಲ್ಲೂ ಯಾವುದರಲ್ಲಿ ನೀವು ಈ ಕ್ರೈಮ್ ಅಂದ್ರೆ ಈ ಯಾವುದು ಭಾರತೀಯ ದಂಡ ಸಂಹಿತೆ, ಅದರಲ್ಲೂ ಸಹ ನೀವು ಕೆಲವೊಂದು ವಿಷಯಗಳನ್ನ ನೋಡಿರ್ತೀರ. ಅದರಲ್ಲಿರುವ ವಿಷಯಗಳನ್ನು ಸಹ ನೀವು ತುಲನಾತ್ಮಕ ಅಧ್ಯಯನ ಮಾಡ್ತೀರಾ. ಸೊ ಹಿಯರ್ ದ ಮೋಸ್ಟ್ ಕಾಮನ್ ಕ್ವಶನ್ ವಿ ಕ್ಯಾನ್ ಸಿ ಅಂಡರ್ ದಿಸ್ administration of justice, we can see the question that is with regard to the explain the primary and secondary function of the administration of justice. With regard to the mind map 5, the question will come up in the examination in this way. Explain the primary and secondary function of the administration of justice. So in this way, they may give, certain times they may give the question like this. Explain the secondary function of court of law. So in this way, the question may come up in the examination. But we should not get disturbed with regard to those things. And in this way, the question may also come up. Explain the necessity of administration of justice. ಅಂದರೆ ಇದರಲ್ಲಿ ನಾವು ಇದನ್ನೆಲ್ಲ ನೋಡಿದೀವಿ. ಏನು ನ್ಯಾಯ ಅಂದ್ರೆ ಏನು, ನ್ಯಾಯ ನಿರ್ವಹಣೆ ಮಾಡುವ ನಿಟ್ಟಿನಲ್ಲಿ ಇರುವಂತ ಒಂದು ನ್ಯಾಯದ ವಿಧಾನಗಳು ಯಾವುದು. ಸೊ ವಿಚ್ ಆರ್ ಆಲ್ ದಿ ಕೈಂಡ್ಸ್ ಆಫ್ ಜಸ್ಟಿಸ್? ದ ನ್ಯಾಚುರಲ್ ಜಸ್ಟಿಸ್, ಲೀಗಲ್ ಜಸ್ಟಿಸ್, ಸಿವಿಲ್ ಜಸ್ಟಿಸ್, ಕ್ರಿಮಿನಲ್ ಜಸ್ಟಿಸ್. ಸೊ ವಿ ಶುಡ್ ಗೆಟ್ ಥರೋ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ ಆಲ್ ಕೈಂಡ್ಸ್ ಆಫ್ ಜಸ್ಟಿಸಸ್. ನಾವು ಯಾವುದೋ ಒಂದಕ್ಕೆ ನೋಡ್ಕೊಂಡು ಹೋಗಿ ಎಕ್ಸಾಮ್ ಅಲ್ಲಿ ಬರೀತೀವಿ ಅಂದ್ರೆ ಸಾಧ್ಯ ಆಗಲ್ಲ. ಇದರಲ್ಲಿ ಪ್ರಶ್ನೆಗಳು ತುಂಬಾ ಸರಳವಾಗಿರುತ್ತೆ. ಎಕ್ಸ್ಪ್ಲೈನ್ ದ ನೆಸೆಸಿಟಿ ಆಫ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಆಫ್ ಜಸ್ಟಿಸ್. ಏನಕ್ಕೆ ಒಂದು ಜಸ್ಟಿಸ್ ಇರಬೇಕು, ಏನಕ್ಕೆ ಒಂದು ನ್ಯಾಯವನ್ನ ನಿರ್ವಹಣೆ ಮಾಡುವಂತ ಒಂದು ಪ್ರಮೇಯ ಏನಕ್ಕಿರಬೇಕು, ಇದರಲ್ಲಿ ಏನು ಪರ್ಪಸ್ ಆಫ್ ಸಿವಿಲ್ ಜಸ್ಟಿಸ್, ಪರ್ಪಸ್ ಆಫ್ ಕ್ರಿಮಿನಲ್ ಜಸ್ಟಿಸ್ ಎಲ್ಲ ನೀವು ಇದನ್ನ ನೋಡಿರ್ತೀರಾ. ನಿಮ್ಗೆ ನಿಮ್ಮ ಲೆಕ್ಚರರ್ಸ್ ಇದನ್ನ ನಿಮ್ಗೆ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿರ್ತಾರೆ. ಸೊ ಹಿಯರ್ you have to discuss the theories of punishment also. So on this aspect also, the question may come up in the examination with regard to the theories of punishment. That is a deterrent theory, retributive theory, preventive theory, reformative theory. So in this way, the question may come up with regard to the theories of punishment. ಇದನ್ನ ನಾನು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡೋದಕ್ಕೆ ಇವಾಗ ಸಾಧ್ಯ ಆಗಲ್ಲ. ಸೊ ಹ್ಯಾವ್ ಎ ಗ್ಲಾನ್ಸ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ ಥಿಯರೀಸ್ ಆಫ್ ಪನಿಷ್ಮೆಂಟ್ ಅಂಡ್ ಸೆಕೆಂಡರಿ ಫಂಕ್ಷನ್ಸ್ ಆಫ್ ದಿ ಕೋರ್ಟ್ಸ್, ದಟ್ ಈಸ್ ಆಕ್ಷನ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ದ ಸ್ಟೇಟ್, ಡಿಕ್ಲರೇಷನ್ ಆಫ್ ರೈಟ್, ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್, ಟೈಟಲ್ ಆಫ್ ರೈಟ್. ನೆಕ್ಸ್ಟ್ ವಿ ಕ್ಯಾನ್ ಗೋ ಟು ದಿ ಮೈಂಡ್ ಮ್ಯಾಪ್ 6, ದಟ್ ಈಸ್ ಲಾ ಆಸ್ ದ ಡಿಕ್ಟೇಟ್ ಆಫ್ ರೀಸನ್, ದಟ್ ಈಸ್ ನ್ಯಾಚುರಲ್ ಲಾ. ಈ ನ್ಯಾಚುರಲ್ ಲಾ ಅಂದ್ರೆ ನೈಸರ್ಗಿಕ ಕಾನೂನಿನ ಬಗ್ಗೆ ನೀವು ನೋಡಿದ್ದೀರಾ. So here in Rome, this natural law has been taken its birth. It is also called as the divine law. Andre even though today also, in spite of all the laws, we are following this natural law. So probably you know in CRPC there is one section is there. So section 151 that will speak with regard to it has been given to the liberty of the court to give any other remedy, any extra remedy which has not been prayed for, which the court deems fit. So likewise, with regard to the Supreme Court, the High Court, they can give any other remedies. They can show their judicial activism. ಅಂದ್ರೆ ಈ ನೈಸರ್ಗಿಕ ಕಾನೂನು ಇತರೆ ಕಾನೂನುಗಳು ಇದ್ರೂ ಸಹ ಅದೇನಪ್ಪ ಅಂತ ಹೇಳಿದ್ರೆ ಅಂತ ಒಂದು ಆ ನೈಸರ್ಗಿಕ ಕಾನೂನಿನ ಒಂದು ಏನು ಚಲಾವಣೆಯನ್ನ, ಆ ಪದದ ಚಲಾವಣೆಯನ್ನ ನಾವು ಈ ತಳಹದಿಯ ಒಂದು ನ್ಯಾಯಾಲಯಗಳಿಂದ ಕಟ್ಟಕಡೆಯ ನ್ಯಾಯಾಲಯ ಯಾವುದು ಒಂದು ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದವರೆಗೂ ಅದನ್ನ ನಾವು ಏನ್ ಮಾಡ್ತೀವಿ, ಅದನ್ನ ನೋಡ್ತೀವಿ. ಸೊ ದಟ್ ಈಸ್ ದ thing we can see. That is, in the examination they may give the question like this: discuss the natural law theory, state the criticism against the natural law theory. So you have to discuss the natural law theory. ನೀವು ನ್ಯಾಚುರಲ್ ಲಾ ಥಿಯರಿ ಬಗ್ಗೆ ಒಂದು ಚರ್ಚೆ ಮಾಡಬೇಕು. ಅದಕ್ಕೆ ಏನು ಕ್ರಿಟಿಸಮ್ಸ್ ಏನಿದೆ ಅದರ ಬಗ್ಗೆ ಬರೀಬೇಕಾಗುತ್ತದೆ. ಯಾವುದರಲ್ಲಿ? ಈ ಲಾ ಇಸ್ ದ ಡಿಕ್ಟೇಟ್ ಆಫ್ ರೀಸನ್, ನ್ಯಾಚುರಲ್ ಲಾ ಬಗ್ಗೆ ನೀವು ಇದನ್ನ ಆ ಪ್ರಶ್ನೆಯನ್ನ ಬರೀಬೇಕಾಗುತ್ತದೆ. Then we can go to the mind map 6, that is law as the command of sovereign, imperative law. ಇದು ನಮ್ಮ ಸ್ಟೂಡೆಂಟ್ಸ್ಗೆ ತುಂಬಾ ಭಯ ಹೋಗುತ್ತೆ. ಈ ಕ್ವಶನ್ ಕೇಳಿದ ತಕ್ಷಣ ಲಾ ಇಸ್ ದ ಕಮಾಂಡ್ ಆಫ್ ಸಾವರಿನ್ ಇಂಪರೇಟಿವ್ ಲಾ, ಯಾರಪ್ಪ ಇದನ್ನ ಬರೆದಿದ್ದಾರೆ, ಏನೋ ತುಂಬಾ ಇದರಲ್ಲಿ ಗಹನವಾಗಿದೆ, ತುಂಬಾ ಭಯ ಬಿದ್ದ್ಬಿಡ್ಬೇಕು ನಾವು ಅಂತ ನಾವು ಅನ್ಕೋತೀವಿ. ಅದನ್ನ ಜಾನ್ ಆಸ್ಟಿನ್ ಅವರು ಇದನ್ನ ಪ್ರತಿಪಾದನೆ ಮಾಡಿದ್ದಾರೆ. ಜಾನ್ ಆಸ್ಟಿನ್, he is believed to be the father of English jurisprudence. So he thinks that what is the law? Law we have to accept as it exists in the present form. He thinks that he divided the law into properly so-called and improperly so-called. He divided into two forms. That is properly so-called and law improperly so-called. So he is also under the prominent person under the analytical school. So here he thinks that law is a command of sovereign which obliges a person or persons to a course of conduct. That means here there is something is there. That means with regard to the law, there will be some system is there. It will dictate the rules. So the subjects they have to follow. So that is the meaning of this law is the command of sovereign. So there is no, we need not have to worry too much with regard to this aspect. We have to write with regard to the John Austin, his book and his definitions, and we have to write some criticism with regard to the analytical school, that is with regard to the John Austin. Normally the question will be asked with regard to this aspect, law as the command of sovereign. So this is normally we can see in the examination. So that this with regard to the law as the command of sovereign. And next one is, here we can go to the next, law as the practice of courts, that is with regard to the legal realism. Here also the question will come, discuss the legal realism, how it is different from the other theories. That is there are so many theories are there with regard to the legal realism. Here we have to discuss with regard to the concept of the legal realism. Here also, this is also expected question may come up with regard to the legal realism. And there are other aspects are there with regard to the legal realism. But normally there will be straightforward questions will be there with regard to the legal realism. And if you get prepared for this question, discuss the legal realism, how it is different from the other. We have to distinguish between the different the schools with regard to the legal realism, different the theories of law. That means here, not rather than schools, we have to discuss with regard to the theory of law. And next one is, here we can go where another is law as a system of rules sorts theory. That means normally we don't find this aspect in the examination, but certain times they may give with regard to the Hart's theory of the law, how the law as a system of rules will come under the Hart's theory. Next one is this pure theory of law, Kelsen theory of law, that is Grandaram. This is the most important question. So on this one, normally there may be short note question may be there, or there will be main question will be there with regard to the Kelsen theory of law. That is, Kelsen theory, he equates the law with regard to the science of law. He thinks that he wants to keep away all the other aspects. For example, sociology, political science, metaphysics. So he wants to he wants to keep away the other things from the law, because he expects the pure theory of law. That is, he thinks that he sees that law as a normative science. Here, most of the students, they got, they much discuss, they will think so much of thing with regard to the Grandaram. What is this Grandaram? Here, Grandaram is nothing but a basic Naram. For example, if a person commits any mistake, for example, if a person enters anybody's house and he commits a murder of a person, other person, there are series of consequences will be there. There are series of consequences will be there. That is house trespass and taking away the life of a person. Likewise, here there is a series of consequences of the offenses will be there, and there is a punishments also will be there under different sections, under different penal laws, under different laws. So here we can find the pyramid of norms, pyramidal structure. Probably you know how the pyramid will be there. Probably you can remember how the pyramid will be there. Here, what happens? The Grandaram will be in the apex. ಅಂದ್ರೆ ಏನೇನು ತುಂಬಾ ಇದೇನೋ ತುಂಬಾ ಗಹನವಾದ ವಿಷಯ ಅಂತ ನೀವು ತುಂಬಾ ತಲೆ ಕೆಡಿಸ್ಕೊಳ್ಳಂಗಿಲ್ಲ. ಗ್ರಂಡಾರಂ ಬಗ್ಗೆ ನೀವು ಹೆಚ್ಚಿನ ತಲೆ ಕೆಡಿಸ್ಕೊಳ್ಳಂಗಿಲ್ಲ. ಅಂದ್ರೆ ಗ್ರಂಡಾರಂ ಏನಂದ್ರೆ ಅದು ಸುಪ್ರೀಂ ಲಾ, ಅಂದ್ರೆ ಅದು ಮೇಲ್ಪದರದಲ್ಲಿ ಇರುತ್ತೆ. ಎಲ್ಲಿ ಒಂದು ಪಿರಮಿಡ್ ಅಲ್ಲಿ ಮೇಲ್ಪದರದಲ್ಲಿ ಇರುತ್ತೆ. ಕೆಳಗಡೆಯಿಂದ ಯಾವ್ಯಾವ ಒಂದು ಸೀರೀಸ್ ಆಫ್ ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್, ಅಂದ್ರೆ ಚೈನ್ ಆಫ್ ಆಕ್ಷನ್ಸ್. ನಾನು ಹೇಳಿದ್ನಲ್ಲ, ಇವಾಗ ಒಬ್ಬ ವ್ಯಕ್ತಿಯ ಒಬ್ಬನ ಮರಣಕ್ಕೆ ಕಾರಣ ಆದ ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಸುಮಾರು ಕಾರಣಗಳಿರುತ್ತೆ, ಸುಮಾರು ಒಂದು ಪೀನಲ್ ಆಕ್ಷನ್ಸ್ ಇರುತ್ತೆ, ಸುಮಾರು ಒಂದು ಕಾನೂನಿನಲ್ಲಿ ಶಿಕ್ಷೆ ಇರುತ್ತೆ. ಆದ್ರೆ ಮೂಲ ಒಂದೇ. ಆ ಮೂಲವನ್ನೇ ನಾವೇನಂತ ಕರಿತೀವಿ? ಗ್ರಂಡಾರಂ ಅಂತ ನಾವು ಕರಿತೀವಿ. ಅದರಲ್ಲಿ ಏನ್ ಬರೀಬೇಕು ನಾವು? ಗ್ರಂಡಾರಂ ಇಸ್ ಎ ಬೇಸಿಕ್ ನಾರಂ. ಸೊ he is away from this the natural science. Here in natural science there is for everything there is a cause and effect will be there. ಅಂದ್ರೆ ನೀವು ಸೈನ್ಸ್ ಅಲ್ಲಿ ನೋಡ್ತೀರಾ, ಇದು ಮಾಡಿದ್ರೆ ಇದಾಗುತ್ತೆ. ಆದ್ರೆ ಇನ್ ಲಾ ವಾಟ್ ಈ ಥಿಂಗ್ಸ್, ವಾಟ್ ಲಾ ಆಟ್ ಟು ಬಿ, ಅಂದ್ರೆ ಕಾನೂನು ಯಾವ ರೀತಿ ಇರಬೇಕು ಅನ್ನೋದನ್ನ ಹೇಳ್ತಾರೆ. ಸೊ ಹಿಯರ್ the questions will come in the examination with regard to the Grandaram or Kelson's theory of law. Here also you can see, if you refer the previous question papers, you will get number of questions with regard to these things. And here what happens, if I give certain questions, if it doesn't come, then you will feel bad. That's why I am giving you almost all the questions from the entire jurisprudence, so that you will also have certain idea. Because most of times you will feel difficulty with regard to the question paper, how to write, what is meant by Grandaram, what is meant by Austinian theory, what is the analytical school. Likewise, you may feel difficulty with regard to those aspects. So next, under with regard to the mind map 7, that is question of law and question of fact. Here in exams they may ask you with regard to the differentiate between the question of law and the question of fact. So here also they may ask you the differentiate with regard to this question of law and question of fact. These things you easily follow. The court will find out the answer if it doesn't find out the answer in the question of law. So what is the question of fact, you know, that is left to the court. Here there are certain examples has been given. You can read this one, then you can easily follow. Here absolutely you don't have the time, that's why I want to cover the question as early as possible. In exams it may come for the short notes. Write a note on the question of law and question of fact. In this way the questions may come up in the examination. And next one is with regard to the the schools of jurisprudence, it is very much important. Here there are so many schools are there with regard to the jurisprudence. Here sociological school is there, and there are so many, the schools are there with regard to the historical school of jurisprudence is there. Likewise, the philosophical school of jurisprudence is there, comparative school of jurisprudence is there. Likewise, there are so many schools of jurisprudence are there. But normally, the question will be on the sociological school of jurisprudence. Explain the sociological school of jurisprudence. In this way, the question will come up in the examination, because sociology has got very much intimacy with regard to jurisprudence, because the law will be how it is effective is when there is a societal control. Here law will not be successful. And ಕಾನೂನು ಏನು ಎಲ್ಲ ಕಾನೂನು ಸಕ್ಸಸ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, with regard to the abolition of beggary, here the law is not successful because there is a mercy is there in the society. So here in society, when the law will be successful, when there is a societal control is there. So you read this one, you get prepared for the question, explain the sociological school of jurisprudence, and you can get prepared for other the question, other aspects also. Here you can slowly pause it. You can read these things for your brush up of the ideas. I have made this format. And next one is sources of law. This is 100% guarantee. With regard to this one, the question will normally come with regard to the either legislation, precedent, custom, or anything. Normally they will give with regard to the legislation. Here, discuss the legislation as a source of law. In this way, normally we can see how the legislation will prove to be a source of law. In this way, they may give the question with regard to the precedent also. With regard to the custom also they can give. Discuss the precedent as a source of law. Discuss the custom as the source of law. In this way, the question may be given in the examination. So that's why get prepared with regard to these questions. So then it will be very much easier. Certain times they may ask you, discuss the legislation as a source of law. What are the advantages of legislation as a source of law over other sources of law? In this way, the question may also come up. ಅಂದ್ರೆ ಈ ಕಾನೂನಿನ ಮೂಲಗಳು ಕ್ವಶನ್ ಒಂದು ಪ್ರಶ್ನೆಯಲ್ಲಿ ಈ ಲೆಜಿಸ್ಲೇಷನ್ ಬಗ್ಗೆ ಒಂದು ಕೇಳಬಹುದು. ಅಂದ್ರೆ ಒಂದು ಶಾಸನಗಳ ಬಗ್ಗೆ ಒಂದು ಪ್ರಶ್ನೆ ಕೇಳಬಹುದು. ಅಂದ್ರೆ ಯಾವ ರೀತಿ ಕಾನೂನಿಗೆ ಶಾಸನಗಳ ಒಂದು ಮೂಲದ ಬಗ್ಗೆ ವಿಶ್ಲೇಷಣೆ ಮಾಡಿ ಅಂತ ಕೊಡಬಹುದು. ಅದೇ ರೀತಿಯಲ್ಲಿ ಈ ಶಾಸನವು ಬೇರೆ ಒಂದು ಕಾನೂನಿನ ಮೂಲಗಳ ಮೇಲೆ ಹೆಚ್ಚಿನ ಹಿರಿಮೆಯನ್ನ ಯಾವ ರೀತಿ ಹೊಂದಿದೆ. How the legislation has got the advantages over the other sources of law. Other sources of law means that is precedent, custom, agreements, etc. So you get prepared for this question. It is normally, it has been given. That's why the students get what you call they will get fear with regard to this sort of questions. But it is very simple if you know the question and answers. And next one is, here the key terms view is there. Here also with regard to the short notes they may give. These they may ask you with regard to the certain aspects with regard to the this arbiter dictum is very much important. With regard to that one, in short notes they may ask the question. Next one is custom. Custom, with regard to custom also, the question we may see in the question papers. There are so many questions will come up with regard to the custom. Here with regard to the custom, there may be questions with regard to discuss the essential requisites of the valid custom. discuss the essential requisites of the valid custom. That means what are the essentials of the valid custom ಅಂದ್ರೆ ಈ ಈ ರೂಢಿಗಳಿಗೆ ಇರುವಂತಹ ಒಂದು ಅತ್ಯವಶ್ಯಕ ಅಂಶಗಳನ್ನ ಚರ್ಚಿಸಿ. ಸೊ ದ ಕ್ವಶನ್ ಮೇ ಕಮ್ ಅಪ್ ಇನ್ ದಿ ಎಕ್ಸಾಮಿನೇಷನ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದ ಕಸ್ಟಮ್. ಸೊ ಇನ್ ದಿಸ್ ವೇ ದ ಕ್ವಶನ್ ಮೇ ಕಮ್ ಅಪ್ ಇನ್ ದಿ ಎಕ್ಸಾಮಿನೇಷನ್. ಇದೇ ನಿಮ್ಗೇನು ಕಷ್ಟ ಆಗಲ್ಲ. ನಿಮ್ಗೆ ಹಿಂದೂ ಲಾ ಅಲ್ಲೇ ನೋಡಿದ್ದೀರಾ ಈ ಕಸ್ಟಮ್, ಮತ್ತೆ ಬೇರೆ ಬೇರೆ ಒಂದು ಕಾನೂನಲ್ಲಿ ನೋಡಿರ್ತೀರಾ. ಅದೇನು ತುಂಬಾ ಕಸ್ಟಮ್ ಅನ್ನ ಏನು ನೀವು ತುಂಬಾ ತಲೆ ಕೆಡಿಸ್ಕೊಳ್ಳೋಂಗೆ ಏನಿಲ್ಲ. ಅದರಲ್ಲಿ ನೀವು ಹಿಂದೂ ಲಾ ಅಲ್ಲಿ ಏನು ಸೆಕ್ಷನ್ 7 ಅನ್ನ ನೋಡಿರ್ತೀರಾ ಹಿಂದೂ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್ ಅಲ್ಲಿ. ಅದನ್ನ ಯು ಹ್ಯಾವ್ ಟು ಡಿಸ್ಕಸ್ ಇನ್ ಎ ವೆರಿ ಅನಾಲಿಟಿಕಲ್ ವೇ. ದಟ್ ಮೀನ್ಸ್ ವಾಟ್ ಆರ್ ದ ರಿಕ್ವೈರ್ಮೆಂಟ್ಸ್ ಆಫ್ ದಿ ವ್ಯಾಲಿಡ್ ಕಸ್ಟಮ್. ಇನ್ ದಟ್ ವೇ ಯು ಹ್ಯಾವ್ ಟು ಡಿಸ್ಕಸ್. ಹಿಯರ್ next the aspect is that is the legislation. So with regard to legislation also there are so many questions will come up in the examination with regard to the legislation. So that is also very much important. And next chapter is that is a precedent. Precedent also they will ask in one or two question papers with regard to precedent there is a question is there, but majority there will not be what you call the questions with regard to the precedent, but there may be we cannot say that the question may not come in the exam with regard to the what you call precedent. Here with regard to the precedent, certain this question is normally will come, that is a ratio decidendi. Here that is a ratio decidendi. With regard to this one, normally there will be a start notes will come. What is ratio decidendi? State how it is determined. That is, what is ratio decidendi? State how it is determined. Here this will come under the precedent chapter. ಅಂದ್ರೆ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ. ದೇರ್ ಇಸ್ ಅಥಾರಿಟಿವ್ ಪ್ರೆಸಿಡೆಂಟ್ ಇಸ್ ದೇರ್, ಪೊಲಿಸಿವ್ ಪ್ರೆಸಿಡೆಂಟ್ ಇಸ್ ದೇರ್, ಅಂಡ್ ಒರಿಜಿನಲ್ ಪ್ರೆಸಿಡೆಂಟ್ ಇಸ್ ದೇರ್, ಡಿಕ್ಲರೇಟರಿ ಪ್ರೆಸಿಡೆಂಟ್ ಇಸ್ ದೇರ್. ವಾಟ್ ಇಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಮೀನ್ಸ್ if some aspect is there which has been accepted, which has been followed certain time. So if for example if there is a judgment or decision of a court has come with regard to the certain aspect, so same decision will be has to be followed by the lower courts. For example, in higher court with regard to the some specific question of fact or question of law has been decided, that is some settled law is there, the lower courts they have to follow the precedent of the higher court. That is meant by precedent. Here you concentrate with regard to the aspect of ratio decidendi and stare diseases. Next one is that is the possession. So with regard to the possession, with regard to the other aspects, normally these are the legal concepts. With regard to this one, there will be normally invariably they will give the questions with regard to the possession. What is possession? What are the constituent elements of possession? ತುಂಬಾ ಈಸಿ ಕಂಡ್ರಿ ಇದು ಪೊಸೆಷನ್ ಅಂದ್ರೆ ಸ್ವಾಧೀನತೆ ಅಂದ್ರೆ ಏನು? possession in law, possession in fact. What is possession? What are the constituent elements of possession? So here with regard to this one, there will be questions they will come up with regard to possession. Differentiate between possession in law, possession in fact. ಅದರ ಬಗ್ಗೆ ಈ ತರ ಕೇಳಬಹುದು ಅಥವಾ ಈ ರೀತಿಯಾಗಿ ಸಹ ನಿಮಗೆ ಕೇಳಬಹುದು. ಪೊಸೆಷನ್ ಬಗ್ಗೆ ಸಹ ಕೇಳಬಹುದು. Next one is ownership. With regard to the ownership also, there are so many. It is also definite question. Discuss the various kinds of ownership. And explain the idea of ownership, and also the difference between the trust and beneficial ownership. So in this way, they will give the question with regard to the ownership. If you refer the previous question papers, you can able to see there are so many questions are there with regard to the ownership, and you can distinguish between the ownership and the possession. Here various kinds of ownership. So it is very easier if you refer the V.D. Mahajan book. You can easily follow. What you have to do, you have to read this jurisprudence as a story book. ಇದನ್ನ ಸ್ಟೋರಿ ಬುಕ್ ತರ ಓದಿದ್ರೆ ನಿಮ್ಗೇನು ಕಷ್ಟ ಆಗಲ್ಲ. ಯಾವ ನೀವು ಭಯ ಬಿತ್ಕೊಂಡು ಓದ್ತೀರಾ ಅವಾಗೆ ಕಷ್ಟ ಆಗೋದು. ಅಂದ್ರೆ ಇದರಲ್ಲಿ ಏನೋ ನೀವು ತುಂಬಾ ಜಾಸ್ತಿ ಬರಿಬೇಕಂತನೂ ಏನು ನಿಮ್ಗೆ ಎಕ್ಸ್ಪೆಕ್ಟೇಷನ್ ಮಾಡಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಒನ್ ಇಸ್ legal rights. With regard to legal rights also, there will be, you need not have to worry. Here with regard to the legal rights, what is the legislation, kinds of subordinate legislation and the analysis of rights. So likewise, there are certain questions will be asked with regard to the legal rights. ಅದರಲ್ಲಿ ಈ legal rights ಅನ್ನೋದ್ರ ಬಗ್ಗೆನೂ ಸಹ ನಿಮಗೆ ಸುಮಾರು ಹಲವಾರು ಪ್ರಶ್ನೆಗಳನ್ನ ಕೊಡಲಾಗುತ್ತದೆ. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಎಕ್ಸ್ಪ್ಲೈನ್ ದ ಕಾನ್ಸೆಪ್ಟ್ ಆಫ್ ಲೀಗಲ್ ರೈಟ್. ಸೊ ಇನ್ ದಿಸ್ ವೇ ದ ಡೈರೆಕ್ಟ್ ಕ್ವಶನ್ಸ್ ಮೇ ಆಲ್ಸೋ ಕಮ್ ಅಪ್ ಇನ್ ದಿ ಎಕ್ಸಾಮಿನೇಷನ್. ಅಂದ್ರೆ ನಿಮ್ಗೆ ಡೈರೆಕ್ಟ್ ಆಗಿ ಸಹ ನಿಮ್ಗೆ ಕೇಳ್ಬೋದು, ಎಕ್ಸ್ಪ್ಲೈನ್ ದಿ ಕಾನ್ಸೆಪ್ಟ್ ಆಫ್ ಲೀಗಲ್ ರೈಟ್. ಅದ್ರ ಬಗ್ಗೆ ನಿಮ್ಗೆ ಕೇಳ್ಬೋದು. ಇದರಲ್ಲಿ ಕ್ಯಾರೆಕ್ಟರಿಸ್ಟಿಕ್ಸ್ ಬರಿಬೇಕು ನೀವು. ಕೈಂಡ್ಸ್ ಆಫ್ ಲೀಗಲ್ ರೈಟ್ಸ್ ಬಗ್ಗೆ ಕೇಳ್ತಾರೆ. ಇದರಲ್ಲಿ ಈ ಕೈಂಡ್ಸ್ ಆಫ್ ಲೀಗಲ್ ರೈಟ್ಸ್ ತುಂಬಾ ಇಂಪಾರ್ಟೆಂಟ್. ಅದರಲ್ಲಿ ಯಾವುದು ರೈಟ್ ಇನ್ ರೆಮ್, ರೈಟ್ ಇನ್ ಪರ್ಸನಮ್, ಇದರಲ್ಲಿ ಎಲ್ಲಿ ನೋಡಿದ್ದೀರಾ ನೀವು? ರೈಟ್ ಇನ್ ರೆಮ್ ಅಂಡ್ ರೈಟ್ ಇನ್ ಪರ್ಸನಮ್ ಯು ಹ್ಯಾವ್ ಸೀನ್ ಇನ್ ದಿ ಲಾ ಆಫ್ ಟಾರ್ಟ್ಸ್. And next one is right in re preporia and right in re alia. So these are all the things. Normally in this right in rem, right in personam, they will ask in the examination, right in re preporia and right in re alia. So here, how to know whether you have to know, you have to go through the subject, you have to see the subject and you have to understand this. It is not so much difficult. You can go to the Google also. Immediately you can get the meaning. What is right in rem? That is the right available against the entire world. That is right in personam is it is available to against the particular person. So in this way, you can get the idea with regard to this thing. Here in the examination they will ask you with regard to these things, and they may ask you with regard to the what is meant by legal right also. The direct question may be asked in the examination. Here, what is legal right? Describe the Hoffield's concept of right in a wider sense. ಇದರಲ್ಲಿ ಯಾರೋ ಹಾಫೀಲ್ಡ್ಸ್ ಕಾನ್ಸೆಪ್ಟ್ ಅಂದ್ರೆ ಹಾಫೀಲ್ಡ್ ಏನ್ ಹೇಳಿದಾರಪ್ಪ, ಹಾಫೀಲ್ಡ್ ಲೀಗಲ್ ರೈಟ್ ಬಗ್ಗೆ ಏನ್ ಹೇಳಿದಾರ ಅನ್ನೋದನ್ನ ನೀವು ಬರಿಬೇಕಾಗುತ್ತದೆ. ನೆಕ್ಸ್ಟ್ ಇನ್ ಇಸ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದ ಪರ್ಸನ್. ಪ್ರಾಬಬ್ಲಿ ಯು ಹ್ಯಾವ್ ಸೀನ್ who is a person, that is with regard to this one. Normally they will ask you with regard to the animal, with regard to the dead person, what is his personality, what is about the unborn person. So in this way, the question may be asked. Even there question will be asked with regard to the company as a artificial person. The DT is the artificial legal person. In this way, the question may be asked in the examination with regard to the person. For example, discuss the concept of personality with special reference to the unborn person. Write a note on corporate personality. In this way, the question may come up. Discuss the concept of personality or with reference to unborn person or dead person or animal, or write a note on corporate personality. In this way, the question may come up in the examination. Next, with regard to the investigative title, divestigative title, they may give in the for the short notes. Here, with regard to substantive law, procedural law, they may give with regard to the law of procedure, and with regard to this valuation of evidence with regard to this aspect, there are certain times the questions may be there with regard to the conclusive proof. With regard to the valuation evidence, there will be some questions will be there in the examination with regard to this aspect. So that's why you get prepared. Normally it will given for the short notes, the divestitive title, the substantive law or procedural law. They may give for the short notes. Next one is law of property. So with regard to what we have to see, the servitudes, lease, securities, trust. So with regard to this one, the certain questions will be there. You can look into the previous papers. Why I am doing this mind map? What are all the things will come in these aspects? So easily you can find, you can get the questions in the question paper bank. Now in the YouTube you are having so many what you call question paper banks with regard to these previous question papers. You can easily follow, but you should know with regard to which chapter which question will come. Then you can easily able to write. If you get a slightest clue, you can able to write the answer. You can write the full-fledged answer. But when you don't get the clue, then the difficulty will come. In a Ju re aliena, jura in re propria. Idra ಬಗ್ಗೆ ಸಹ ನಿಮಗೆ the question will come. In exam, jura in re propria, jura in re aliena. So with regard to that one, the question will come. Distinguish between the jura in re propria, jura in re aliena. The question will come in the examination. That is obligation. Here with regard to the obligation also, we can expect the question. Explain the nature of obligation and kinds of obligation. So in this way, the question will come in the examination. So I am telling you how the questions will come in the examination. They may ask you, certain times the question will be there. Different sources of obligation. Explain the law as a dictate of reason. So in this way, the question will come. You should not get disturbed when you understand this concept in whole length, that is sources of obligation. Then it will not be very much difficult for you to answer the question. If you don't study the subject in full length, if you do not make the mind map with regard to the certain aspects, then you will find the difficulty with regard to writing the answer. Then you will find the difficulty in writing the answer. Next is the liability. Here civil liability is there, criminal liability is there, damnum sine injuria. This you have seen in the law of torts with regard to these things. Number of times, very easy subject, very wonderful subject, that is the law of torts. There you have seen all kinds of liability. That is civil liability, criminal liability, absolute liability, and strict liability. All the things you have seen. That means only thing you have to write in the what you call critical, you have to make the critical analysis with regard to those things only. So it is very simple. But as you think, the jurisprudence seems to be very difficult. It's not a difficult thing. But you have to read this subject as a story book. You study very simple books. V.D. Mahajan book is very easy book. Don't go for the English authors. Study the Indian authors' books. Then it will be very much easier for you. So, apart from this one, you have got certain questions with regard to the negligence. What is negligence? Discuss the theory of negligence. And with regard to certain times, they may ask you with regard to the certain aspects. Explain the different theories of punishment. And explain the nature and scope of jurisprudence. What is personality? Explain the advantage of incorporation. Explain the Austin theory of law, function and purpose of law. And write a note on international law as a law. Describe the law as a system of rules. State the need for administration of these things we have discussed. And write a note on reformative theory, that will come under the theory aspect. Likewise, certain things will be there. You have to note down these things, and certain times they may ask you with regard to the ownership, possession, and the difference. And with regard to possession, they may ask you with regard to the only one time they will ask you with regard to the decided cases. Normally, they will not ask you with regard to the decided cases. That is, discuss the possession in law with the decided cases. Okay, students, I have done this video from the examination point of view only. In coming days, I will make the individual videos. That means for each chapter, each aspect, each concept, I will make the individual video. So this is for this video has been done from the point of view of the examination, so that so many students they are requesting me to do the video with regard to this jurisprudence. They think that there are so many things they got confused with regard to the jurisprudence. So here in jurisprudence you need not have to write too much, and it is not like other subjects. Here you need not have to follow the steps of how to write the answer with regard to other subjects. So here whatever I thought of giving you the way in which I wanted to tell you in simple way, I have made it as very much simpler. If you find any difficulty, please make the comments in the comment section. I tried to clarify it. So this video is from the point of view of the examination. Wish you good luck, students.